Well, howdy there, folks. James, Political Friar, coming to you again. I got the law hat on today, and so we're going to talk about another legal topic that came up while I was away on my trip last week or so, and that was the Supreme Court, U.S. Supreme Court, refusing to hear an expedited appeal on Trump's immunity from criminal prosecution. This came up in context of Jack Smith's case in Washington, D.C., with its primary allegation of Donald Trump conspiring against the United States to attempt to overturn the election results of the 2020 election. And that's a criminal charge that occurred at a time when Donald Trump was president. And Donald Trump has asserted that because he was president at the time, he is in effect entirely immune from any kind of legal liability for, frankly, anything at all. Literally above the law, as the case may be. And actually, while he's in office, it might be true. He might actually be literally above the law. I'm not sure if we will ever get the test case of a president murdering somebody while in office and maybe or maybe not being prosecuted, but there's a pretty good constitutional argument that you got to be impeached first before you could be prosecuted. Now, theoretically, the Senate would impeach a president for murder, right? Well, I don't know. But the question is not whether a president has immunity while in office. The question is whether the president has immunity after he's left office. Now, we know the answer to this question on the civil side of the law. The civil side is suing somebody for money, not getting tossed in jail by the government. So on the civil side, we have a series of cases beginning with U.S. v. Nixon and then extending through Clinton v. Jones that say very clearly that presidents are not immune from civil liability for actions that they took while in office, so long as those actions are not within the outer bounds of their official duties as president. So if they're doing things as president with their president hat on, then they are immune from civil liability for those actions. But if they're doing things outside of their role as president, then they aren't. So, for example, when Obama launched a drone strike that killed a U.S. citizen in Yemen, well, that U.S. citizen's family can't sue Obama for that because it was done in the auspices of his office. But if Bill Clinton sexually harassed Paula Jones, well, that's not really part of his job as president. And so, yeah, he is civilly liable for that, even if he was president at the time. So that's the rule on the civil side. It would be pretty absurd for the rule to be different on the criminal side. I think that is a incomprehensible outcome, and it almost certainly will come out at the rule is the same. The rule is that presidents can be criminally liable for crimes that they commit outside the auspices of their office. But the Supreme Court wasn't going to allow the process to be sped up. See, the normal process is you get the ruling at the trial court level, and then it goes to the appeals court, and then it goes to the Supreme Court. Well, what Jack Smith wanted to do was skip that middle step, go into the appeals court, and go straight to the Supreme Court. And the Supreme Court said, nah, we're not going to do it. There are two things that the Supreme Court looks at when they decide whether they're going to skip the appeals court. The first is whether the case is truly important enough to justify skipping that step. And I think the answer to that question was yes. Clearly, this is a case that has enough national importance to skip the appeals court. But the second element is a compelling reason to speed the process up. And the only compelling reason to speed the process up is to get the trial done before the election so that Donald Trump can't immunize himself if he wins. Well, the Supreme Court doesn't see that as a very good reason to speed things up because prosecutions for criminal liability aren't supposed to be accounting for election timetables. It's actually explicitly against Department of Justice policy to take into account elections. And so the Supreme Court says, what's your reason for wanting to speed up? And Jack Smith says, I don't have one, because he can't admit it, because that'd be against departmental policy. And the Supreme Court says, well, you don't have a reason, so you don't win. So it's not going to get to the Supreme Court this question of criminal immunity until the spring, which means that the trial date's going to get pushed back. They currently have a March trial date. That's not going to happen. It's going to be May at the earliest, at the very earliest, and maybe later. And this all plays into Donald Trump's legal strategy, because his legal strategy isn't to win. His legal strategy is to delay until he can get out of it by winning the election. He is, as Chris Christie and Will Hurd put it, running to stay out of jail, and this helps him. It might not matter. It might still get through before the election. I expect it probably will, in particular because the D.C. appeals court, oh, they're on board with speeding it up. They've set an incredibly aggressive briefing schedule with oral arguments happening next month. That's lightning, greased lightning quick for an appellate process. So it'll get in front of the Supreme Court eventually, and there's no doubt in my mind that presidents are not immune from crimes that they commit just by dint of being president. But the argument has to be resolved before you can move forward, and that is just a matter of time. And time's the key. Anyway, that's just my thought. Let me know how wrong I am in the comments down below. Leave me a like. Hit that subscribe button if you haven't already, and know that I really appreciate it. Thanks.